Transferring ownership of property from a parent to a child sounds like a great estate plan and a great way to avoid probate. But today we're going to talk about the reasons why that might not be such a good idea. Reasons we get for people wanting to put property in their kids' names are usually one of these four reasons. The first one is to avoid probate. Second, nursing home protection. Third, to save on taxes. And fourth, to a certain extent, to avoid liability or avoid getting sued and losing all of their assets before they can give them to their kids. This is usually a bad idea because it exposes you to liability once you've transferred those assets to your children and they do something that, well, probably is not such a good idea. And the second reason, it deprives your child of certain tax advantages that they could be entitled to if you had just waited for that transfer to happen after you pass away. Let's look at each of these and why they are usually a bad idea. First is avoiding probate. And true, if you only have one child, it might sound like a really great idea to put everything in joint tenancy with that one child, your bank accounts or your property. But let's look at some of the reasons why that's probably not a good idea. Putting an asset in your child's name, even if it is in just joint tenancy, it still makes it one of their assets. And that's an asset now that you own, co-own with your child. That can be bad because what if they have creditors? What if they have a credit card company or a medical provider who's been trying to collect on them for several years? Now all of a sudden you've put your house in joint tenancy with your child, and now all of a sudden there's an asset for that medical provider or for that credit card company to go after to collect on the debt that your child owes them. So that could be an immediate, very bad situation. The next thing is, what if your child gets divorced? Or what if they get married? Let's say you put your house into joint tenancy with your child and they're married at the time, and then they get a divorce. Well, now all of a sudden your house, because it's held in joint tenancy with your child, is part of the divorce estate. And their ex-spouse or soon-to-be ex-spouse could be and probably is entitled to a portion of the house that you're living in. And that is not a good idea. The next reason is if your child predeceases you. And much like the divorce situation, if your child predeceases you, then all of a sudden their heirs are going to be entitled to their share of your property if it's a house. So let's say your child predeceases you and he is married at the time. So now all of a sudden you don't own a house with your child, you own a house with your stepdaughter or your stepson. And that might not be a good situation depending on your case. But I will tell you probably about 80% of the time, no matter how much you love them, it's not a good situation. The next thing that could happen is, well, you've now given your child an asset, right? And they need to get a loan for something, for anything. And they can just go put that house up as collateral, or at least their interest in the house as collateral for that loan. And they don't probably have to tell you anything depending on which state you're in. So again, if they default on that loan, your house could be up for grabs as part of the collection process for a loan that your child took out because you put your house partially in their name. In each of the cases where you gave your child part ownership or joint tenancy in a property or a bank account, you lose control of that asset. And it then becomes up for grabs for their spouse, for their children, your grandchildren, and creditors. And that is a situation, again, that you don't want to put yourself in, especially late in life. The second reason people give for gifting or putting a house or a bank account or something into joint tenancy with their child is to save taxes. And guys, I don't know why people think that. I guess it's from TV and the movies and different things. But if you've seen in our other videos, right now, unless your estate is over $11,580,000 for a single person and over $23 million for a married couple, you don't need to worry about estate tax. So if you do put a property into, let's say it's a house, let's say you put your house in joint tenancy with your child, or maybe it's a bank account. Now all of a sudden that child could be subject to income taxes for the portion that you're giving them. And that's because you're doing it during lifetime if it's over the federal estate gift tax annual exemption amount. And that's for another video that you can come back and check as well. But you just need to make sure that when you make these gifts, you're not triggering a taxable event for your child, because that could be a bad situation. The other taxable event that could happen is capital gains. Let's say you bought a house in 1968, for example, for $50,000. Your basis for that house is $50,000, even though today it might be worth $600,000. If you sold the house right now, you would have a capital gains of $550,000. Now, there's certain rules that go into place for you to allow you to purchase a new home within a certain amount of time. But if you give that house to your child in joint tenancy, you could and probably will trigger a capital gains event for your child. So let's see how that can happen. This year, you make a transfer to your child as a joint tenant in your house. Now remember, you bought the house in 1968 for $50,000. So when you do that deed, transferring, making them a joint tenant, they in essence are getting half of the cost basis, or that $50,000. So their basis at the time that you make that transfer is $25,000. Make sense so far? Now, not only do they receive your cost basis, or half of your cost basis, then they also receive half the value of the house. So in other words, half the value of the house is credited to them. So like I said in our example, the house is now worth $600,000. So they get half of your cost basis, which is $25,000 each, and they also get the share of the value of the house on the date that you made that deed, which would be $300,000, right? So because we said the house is worth $600,000, half of that is $300,000. Then you pass away within a couple years and your child sells the house for $600,000. Let's, just for ease of explanation, let's say that it just stayed at $600,000 over those 2 years. Well, remember, your child's cost basis was $25,000, and they also got $300,000 as the value of the house, remember? And then the other $300,000 belonged to you. So on the share that belonged to them, that $300,000 minus the $25,000, they have a capital gains of $275,000, in which they are going to have to pay thousands of dollars in capital gains tax. If the father had instead put the house in his last will and testament, or as you know, like I prefer, his revocable living trust, and made that transfer after death, then his child would have received the house at the $600,000 value. When this child decided to sell the house 2 years later, 3 years later, at $600,000, there would be a zero capital gains, and there would not be a capital gains event. Now, of course, if the child decided to sell the house 2 years later for $650,000, then of course they would have a capital gains at that point of only $50,000, as opposed to the $275,000, because you decided to make that transfer prior to death to avoid probate and presumably to save money. The unintended consequence of that, though, was that you created a taxable capital gains event for your child of almost $300,000. That is not a good situation. The third reason people transfer assets to their children is for nursing home reasons. I know you can do this, but it has gotten more and more strict on the 5-year look back period on whether those transfers were made in anticipation of going to a nursing home. The best way to do this is to plan ahead and get a trust specifically designed so that your assets can go into that trust. You can still have a certain amount of control over them, and they won't get counted for purposes of going into a nursing home. So if you need to do that, or if you're in that situation, talk to your estate planning attorney near you, to your CPA, or to your financial advisor. But don't think that just because you've transferred your assets to your child or your children, that automatically you're going to avoid having to use that money for nursing home purposes. The government has gotten more and more strict on scrutinizing those transfers over the last several years, and I would tell you, seek professional help before you try to make a transfer like that, because in most cases, if you're within that 5-year period, it's probably not going to work. The fourth reason we get is lawsuit protection, and I really don't understand this at all, but I guess, again, from TVs and the movies, people think that if they transfer all of their assets to their kids or to somebody else, that they're going to somehow avoid a lawsuit that they know is coming up. The problem is that if they can prove that you made that transfer in anticipation of a lawsuit, or in anticipation of having to pay some big debt, then the courts are going to probably nullify that transfer, and you're going to be back in the exact same situation you were before. So if that's your situation, you probably need to talk to an attorney or your financial advisor or your CPA again before you make those transfers. And I hate to keep saying that you need to talk to a professional, but if you are in one of these situations, you really do need to talk to somebody who can guide you through the process. Because if you don't, just like that child who had a almost $300,000 taxable capital gains event, it could turn out to be a very bad situation, whether it's owing taxes, owing creditors, or all of your assets ending up with one of your child's ex-spouses. Not a good situation in any of those cases.